briefly. Alpha Catering wanted high-quality Wagyu beef for a high-end event. They clearly told the supplier that the beef must be premium. The supplier agreed and said the beef was premium grade A Wagyu. They also showed a good sample. Based on this, Alpha Catering trusted the supplier, ordered 500 kg and paid a deposit. However, when the beef arrived, it was a lower quality and not the same as the sample. It was also not suitable for a premium event. When Alpha Catering asked for a refund or replacement, the supplier refused.
Section 15 of the Sale of Goods Act 1957, where there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description, and if the sale is by sample as well as by description, it is not sufficient that the bulk of the goods correspond with sample if the goods do not correspond with the description. And Section 17, Subsection 1, Sale of Goods 1957, a contract of sale is a contract for sale by sample where there is a term in the contract expressed or implied to the effect. The application under Section 15, there is an implied condition that goods must match their description. Meatmaster Enterprise provide a written quotation specifically describing the product as premium grade A Wagyu beef. Upon delivery, Alpha Catering discovering the beef lacked the signature marbling of Wagyu and appeared to be a lower commercial grade. Because the physical identity of the beef delivered does not match the grade A Wagyu description relied upon during the contract formation, Meatmaster is breach of this implied condition. Under Section 17, in a sale by sample, the bulk must correspond with the sample in quality. During negotiation, the supplier exhibit a sample of highly marbled Wagyu beef and assured Alpha Catering that the bulk order would be similar quality. The 500 kg bulk delivery did not possess the quality of or characteristic of the sample shown. Since Alpha Catering specifically relied on the sample to make the purchase, the failure of the bulk order to match the sample constitute a clear legal breach.
The relevant case for this case is Case BL Retailer 1967. A contract for the sale of a Herald Convertible White 1961 Twin car was a breach of the section by the delivery of a vehicle consisting of parts of two cars welded together, one of it being earlier than 1961. The court concluded that the buyer doesn't have to buy the goods because it did not match the description that was given.
Let's discuss ethical and professional responsibilities of the seller. First, duty of honest representation and disclosure through trustfulness. Sellers have an ethical obligation to accurately describe their products. This includes quality, grade, origin, and suitability for the buyer's intended purpose. In this case, Meatmaster quoted premium grade A Wagyu beef, showed a highly marbled sample, and assured that the bulk order will be of similar quality. The delivered product was of noticeable lower commercial grade with insufficient marbling. This constitutes misrepresentation, whether intentional or negligent. Even if unintentional, the seller must take responsibility when the product deviates significantly from what was promised. Under Malaysian contract law and general business ethics, the goods must correspond with the description provided in the quotation and any simple samples shown. The Sale of Goods Act 1957 Malaysia implies condition that goods sold by description must match that description, and when a sample is provided, the bulk must correspond with the sample. Second, duty of good faith and fair dealing. In professional business-to-business relationship, there is an expectation of good faith, acting honestly, not taking unfair advantage, and resolving issues amicably when they arise. Upon receiving the complaint, meat master refused the request for replacement or refund and insists the meat was suitable. This rigid stance risks damaging the relationship and could expose them to legal claims like breach of contract and breach of implied conditions. A responsible seller would immediately inspect the delivery, offer a full refund, replacement or credit, especially for perishable goods needed for a time-sensitive event. So, a responsible seller in this situation should have first, immediately acknowledge the quality gap upon complaint. Second, offered a full or partial refund and compensation for inconvenience. Third, investigate internally why the sample and bulk differed. And fourth, use clear specification, for example, detailed grading, certificates, and photos of actual stock.
In conclusion, the supplier did breach the contract, so Alpha Catering can reject the goods and claim a refund for damages. That's all for today's report. This case highlights the importance of honesty in business transactions, especially under the Sale of Goods Act 1957. Suppliers must ensure that the goods delivered match the description, sample, and purpose agreed. That is all from us. Thank you for watching. I'm Hafiz Muzaffar, reporting from Polytechnic Corp.